Well, let me go to my first guest on that big story, former Attorney General of the country who appeared as the senior advocate for Tamil Nadu when a two-judge bench had ruled that there could be timelines set for governors and presidents. Mukul Rohatgi joins us. What do you now make out of the Supreme Court five-judge judgment that effectively overrules what the two-judge bench said? It seems to suggest that any decision taken by the governor and president when it comes to withholding of bills is not subject to judicial review.
So, Rajdeep, first things first. This is what is called advisory jurisdiction. The very meaning of the word advise is that it is not binding either on the person who seeks the advice or even on courts. This is a special jurisdiction to advise or counsel. That's the first thing. This has been so held by the Supreme Court in a catena of judgments from Xavier's case downwards, though it is entitled to great weight because it is nevertheless the wisdom of 5 or 9 judges of the Supreme Court. Second, in my view, this judgment creates more confusion than it seeks to clear. It says that there can't be a time limit set for the governor because no such time limit has been set in the Constitution. Well, that's literally true, but Dr. Ambedkar would be turning in his grave in as much as he would never have thought that governors will act in a partisan fashion all over the nation, will not act with wise counsel, and will delay things intentionally. That was not contemplated by Dr. Ambedkar. That is why there is no such time limit. It was meant that people would rise to the occasion, but sadly, things have fallen rather than rising in the last 75 years of the Constitution.
I may ask you, as a result of this judgment, what happens tomorrow if a governor chooses to sit indefinitely on a bill passed by the legislature, or the president doesn't give assent to a contentious piece of legislation passed by a state assembly? Is this judgment therefore creating the possibility of even more state-center conflicts and actually acting against the federal spirit?
Yeah, so now, Rajdeep, two things. One, on one hand, it says that there can be no restriction on the discretion of the governor. He may act, he may not act, or he may choose one of the three courses available to him. On the other hand, it says that there is a window of quote unquote limited jurisdiction or limited judicial review on a case to case basis where a bench of the court may feel that the governor is inordinately delaying, then the court can, in a limited manner, issue a mandamus. Mandamus is a positive direction to do or not to do or forbear from doing something. Now, once you have that window, then the discretion vests in the bench of the Supreme Court. Now, what is reasonable delay or inordinate delay can vary because it is a subjective term. I may say that 2 months or 1 month is inordinate. You may feel that even 3 months is not inordinate. Who will decide? It will be a benchmark set by the bench concerned. The bill placed before him is the will of the people. Let's not forget, the assembly is the will of the people. If they say the bill should be passed, it should jolly well be passed, unless there is a glaring error or a legal flaw in that bill. Because it can't be that the will of the people of the entire state is pitted against one person. The governor is, after all, one human being. Therefore, he should jolly well pass the bill. And if the bill is illegal, it's for the courts to strike it down. The Constitution does not give him any power to hold back a bill because, in his wisdom, it is illegal or right or wrong. His discretion is very, very limited. So, at the end of the day, there is a window in this judgment. That window will be exercised as per the discretion or the view of the bench concerned. And every day you will have conflicting views. Somebody will say 1 month is too late. Somebody said 3 months is not late. This is the
Right.
confusion which will be caused by this judgment. Now let me come back, a step back a little. I was a counsel for the state of Tamil Nadu in the earlier case, which was decided by a two-judge bench of the Supreme Court, headed by Justice Padiwala. He took the other view, namely that because of the reasons that I have mentioned, no individual can hold back and say, I will not decide or I will decide, whenever I want. In that case, more than 2 years had passed and the bills were still languishing. So the will of the people was being scuttled. So that bench, in its wisdom, set specific time limits that if they
Yes.
don't act within those time limits, there will be a concept of deemed assent. Deemed assent is a it's a fiction of law. You have the concept of deemed consent and assent in various statutes in India. For example, in every municipal law, there is a deemed consent or assent. That if you apply for sanction of building plans for your house, and for 3 months or so, if the corporation does not reply at all, the consent or a sanction is deemed to be granted. They have applied that principle only because every public functionary is accountable to the people, whether it's a
So,
municipal authority, whether it's a governor or a chief minister. Everybody is accountable because the public is
so
supreme.
you're mentioning, therefore, accountability and will of the people again and again. Can I say, Mr. Rohatgi, that this judgment, in your view, only sets back the entire concept of the will of the people being supreme in a democracy? Am I correct that an unelected governor is being given primacy over an elected legislature, and therefore you have a situation where the governor cannot intervene? You believe that the governor must clear what the legislature says. The Supreme Court says governor cannot be a rubber stamp. Uh, you're saying that a governor cannot withhold assent and the court must review it if he withholds it without giving adequate reasons. Am I correct?
Absolutely correct, because the will of the people is supreme. Nobody can hold it to ransom. And as I said, he is not the arbiter of whether it's lawful or unlawful. By and large, it is the courts which will decide. He can assent and say, well, this is the will of the people, unless it's an absurd bill or completely wrong. He will generally say, I've decided, granted assent. If somebody is dissatisfied, please go and challenge it in the courts. The courts are meant to hear a challenge, not the governor. So I would lean in favor of the two-judge bench judgment which set down the timelines, even though it's a little extreme. But at times, you require extreme measures for extreme situations, considering what is happening in the country.
Okay, Mukul Rohatgi is saying Ambedkar would be turning in his grave looking at this judgment. I appreciate you joining us. Strong words there from the former Attorney General.